Stephen Brown, Etienne Lawyers. A quick soundbite. What is a franchise? The question keeps arising with clients as to what is a franchise. Is a license agreement or a distribution agreement a franchise? The answer is determined by Section 4 of the Franchising Code of Conduct. In short, a franchise is anything, whether written, oral or implied, whereby a person grants to another the right to carry on business offering the supply of goods or services in Australia under a system or marketing plan substantially determined by the grantor that is connected to a particular trademark, whether it is a common law or registered trademark. The question was looked at in a number of cases, and one case which illustrates and answers the question succinctly is the decision of Rafferty and Time 2000 West. In that case, the parties were involved in a business venture related to the construction and sale of modular accommodation units. The business arrangement was documented by 3 agreements: a heads of agreement, a joint venture, shareholders agreement and a rights agreement. The venture failed and Rafferty sought repayment of $1.7 million. Justice Pisanko, finding for Rafferty, noted that the question of whether a particular agreement is a franchise agreement within the meaning of the franchising code is determined by reference to the definitions in the code and not by reference to any preconceived notions of other agreements which are not ordinarily understood to be franchise agreements. In other words, Justice Pisanko was saying the clincher is not in the name. Whether you call something a license or a distribution does not mean that it is not a franchise. What is determinative is whether there is a system that has a marketing plan. Justice Pisanko, though, went on to add that there need not be an actual marketing plan in existence at the time the agreement is reached. He said that it will be sufficient for the purposes of clause 4.1b that there be a power in the agreement, which is said to be a franchise agreement, to impose a system or marketing plan substantially determined or controlled by the franchisor at a later date. The lessons to be learned by franchisors and those intending to become franchisors is that the name is not determinative of whether you have or do not have a franchise. So do not think that you can escape the requirements of the Franchising Code of Conduct by having a license or distribution agreement. Also, those who are involved in the promotion of such schemes can become personally liable in certain circumstances. If you require assistance, contact us at Etienne Lawyers.